Welcome to Redirect, Immigration Law and Perspectives, a weekly dive into immigration law and its human consequences. I'm your host, Stephen Robbins, joined this week by Greg McLawsen. He's an attorney in Seattle, Washington, and he's done a real service by digging into this 800-page new rule on public charge. You may have heard that they're cracking down on immigrants who get public benefits or things like that. And we really dive into that rule and what it is and who it affects or doesn't affect. One thing's for sure, it's really going to make my life miserable. And that's the important thing. That's the thing I want everyone to remember is me. No, but seriously, it's hard to know how this rule will be used, but it is now a major tool in the toolbox for people who might want to deny applications for green cards. So enjoy the conversation with Greg. If you like the show, you can become a patron at patreon.com/redirect. We take a pro bono asylum case for every 100 patrons, and we're just chilling at about 125. Maybe we've peaked. I don't know. But share the show around with family or friends who might have questions about this. I think this is also kind of an important episode for immigrants themselves to listen to, people who are thinking about filing green cards or applications for loved ones. Things may be changing, and so definitely worth a listen for those folks as well. You can subscribe on iTunes, Stitcher, Spotify. You can leave a review, say something nice. And of course, as always, we appreciate those comments. Now on to the show. You were on the show, I don't know, when was that? A year ago when they announced this new rule change?
Yeah, and that was in October 2018 that they announced the proposed rules.
Yeah, I wanted to set the table a little bit. Two things. One, as you know, Republicans, one thing they hate is big government, right? And so when they do something as government, you know that it must be, for a really good reason. Because they're very restrained in how they exercise government power. And so what is the justification given for this new rule? And there's a 20-page form that we have to fill out now. What is behind all of this?
Well, let's be fair. It's a 19-page form.
Sorry. Good point.
The justification is that this is an extension of a policy objective that's been crystal clear, at least on the face of U.S. immigration law since 1882 or earlier, which is preventing foreign nationals from becoming a drain on public resources by becoming public charges. So basically, the whole idea is to save the American taxpayer money by preventing immigrant families from using public assistance programs.
Is there something that they pointed to or that they can point to suggest that this is a particular issue that wasn't being solved by what was previously in place? Are there statistics or studies?
Sure. I mean, to even pass rational basis review, which, of course, lawsuits by 13 states and various municipalities are already challenging. But, I mean, even in order to pass rational basis, they had to have something to look to show that this was an actual problem. And in the notice of proposed rulemaking, they had their stats. Advocacy groups have their own stats, too. And there's a divide on the factual issue of whether immigrant families and large families take public assistance at higher rates than others. But they did have stats that they believe support their opinion on that.
Real quick, by way of background, people can go back and listen to our previous interview, but what exists now? What is the current structure? Because it has been a law for a really long time, and it's not like it's been ignored, right? So for people who don't know, what is the current structure like?
There's kind of the de jure standard, which was put into effect by a 1999 policy memorandum. But it almost doesn't matter because that policy memorandum, nobody even really knew about it. So we can talk about what the technical standard was, but the real standard that was in place was basically that if you had a valid I-864, valid meaning it was filled out properly and the sponsor had adequate resources, and absent specifically a serious medical condition. So if you weren't a person who was receiving expensive long-term medical care, and if you had the affidavit of support, the reality was that you were fine. So public charge determinations today and until October 14th are all about the affidavit of support and making sure that you've got a valid one, that assets aren't weird, and that the adjudicator isn't going to have problems with whether they can be converted to cash, blah, blah, blah. It's all about the affidavit of support. That's the current standard.
Do you know anything about what it was like before that, before the affidavit of support was brought about?
It was basically an ad hoc determination by consular officers and then INS adjudicators, which is what Congress had a problem with in 1996. There almost were no real standards for making those determinations.
Let's talk a little bit, I guess, about this 800-page rule. Is it as dramatic as people think? What is really being changed, in your opinion?
I think it's pretty hard to overstate how bad this thing looks, at least on its face. And I mean, almost like the only reason to ratchet down your level of concern is the fact that it's being challenged and that it's so draconian that my guess is that some of those challenges are probably going to result in this thing being enjoined or partially enjoined before October. But if it isn't, it's going to fundamentally change adjustment of status applications. No question about it. The real change is that the affidavit of support, which used to be effectively sufficient to get past public charge determinations, now just gets you to the starting point. So it's now relegated to the bottom of a 7-factor test that's going to put renewed focus on the applicant himself.
For people who might not know, we're talking about people who are either undocumented or people who are here on some sort of temporary status who will be adjusting to permanent resident, which means they'll have a green card and they'll be on some sort of path to citizenship. But it doesn't apply to all permanent residents, right? So who are the people that are exempted or people who are not exempted?
So it applies to everybody who's subject to public charge inadmissibility. And the primary exceptions to those numerically are refugees and asylees. So folks who've been admitted as refugees and asylees, this is kind of skipping ahead to the public benefits part of the rule, but folks who are admitted as refugees or asylees aren't subject to this rule in terms of receiving public benefits. But the vast majority of people who adjust status are doing so on family-based petitions, and all of those people are going to be subject to it.
Right. So like you said before, the structure as it currently exists requires that the petitioner, so if I'm a U.S. citizen, I'm petitioning for a foreign national spouse, I have to sign this affidavit of support. And if I don't earn enough, I need to find somebody else who can sign basically as a co-sponsor. And there's requirements there, right? Tax returns and proof of income, proof of assets if necessary. That already exists. And what you're saying is that is still going to exist essentially, but that's now the lowest rung that needs to be cleared. What are the other 6?
Right. The other 6 factors, and let me just back up here 1 minute, because the ultimate standard, the thing that adjudicators are supposed to be looking at, is whether somebody's more likely than not at any point in the future to receive federally funded public benefits. That's what the adjudicators are supposed to be assessing, is whether the person is more likely than not to receive public benefits. And then the way that they do that is through this 7-factor test. So we're trying to determine more likely or not to get public benefits. How do we do that? We use the 7-factor test. Some of the factors have subparts, maybe five or so subparts. And then in addition to that, there's also their heavily weighted positive and negative factors that are sort of like per se positive and negative inadmissibility findings. Does that all seem simple enough?
Well, I was going to say, I mean, I guess most attorneys will already tell you that the 864, the affidavit of support, is kind of the bane of their existence already. And it's already very common to get a request for evidence where immigration will say, well, you know, your co-sponsor makes 20 times what they need to, but we don't think they earn enough, which is just wrong.
These people will look back to the blissful days where the only thing we had to worry about was the affidavit of support. The evidence that is required for the affidavit of support is a pittance compared to what's going to be required for the new, it's called the I-944 Declaration of Self-Sufficiency.
And just to be clear, I mean, the real victims here, I mean, what's really happening is they're trying to provide new pathways to deny applications or deter applications in the first place. That's the real tragedy. But for a moment, I want everyone to realize that I am also a victim. And so are you. And so,
yes.
so if you know an immigration lawyer, give them a hug. But Let's be a little bit more specific about some of these new requirements and this new sort of law school flow chart.
Let's talk about the factors. And before we do that, I wanted to point out maybe my favorite thing about the rule, which is that the whole thing that adjudicators are supposed to be doing is to forecast within this regulatory crystal ball whether somebody is going to be enrolled in a public benefits program in the future. However, the rule specifically says that one thing that the adjudicators are not to consider is the enrollment criteria for those programs. So tell me if that seems a little bit weird to you, that we are going to be assessing whether an individual is likely to become enrolled in Medicaid, but one thing we won't consider is what it takes to be enrolled in Medicaid. And instead, we're going to look at these 7 factors in the rule. That seems like a problem to me.
Yeah, makes total sense.
Okay, are we doing the 7 factors?
Yeah, let's talk about those. And then I want to get into, because this is the big question we've been having and people have, I think, what are the benefits people can and can't get? But let's talk about what they're going to be looking at pulling back this curtain.
And all of these factors are things that are, so CIS is going to get their facts by looking at the 944 form. So all of these factors are reflected in various questions on the form. Number 1 is age. So we have now a clear preference in favor of folks ages 18 to 65 retirement age. And that basically is as bad as it sounds for applicants. So if you are under age 18 or over age 65, you're basically going to have to make a steeper showing on public charge inadmissibility, period. The only slight rub there is that the rule exempts minors who will automatically acquire citizenship by residing with a U.S. parent. So if you have the son of an immediate relative, U.S. citizen father, and a foreign national mother, and he comes and adjusts, then he won't be subject to this bar. So that's nice, but everybody else will be.
But if you want to bring over your father, your mother, maybe to take care of them, that's going to be a little bit more complicated.
Those folks are going to have a steeper showing. Number 2 is health. So this is no huge departure from what folks are already familiar with. But CIS is now going to take a long, hard look at the G639 medical report to see if there's anything that they think, in their educated opinion as medical doctors, will require long-term medical care. And then if you do have an issue, so if you're in the midst of chemotherapy, you're sure going to need to be able to demonstrate how you're going to be paying for that care. So that's something that practitioners are already on the lookout for, I think and hope. But it's just that it's going to be done in a more systematic way than it is currently.
Right. Okay. I think I can handle those first two.
Sorry if this is turning into a CLE monologue. Factor number.
No. It's fine. It's, progressively more depressing. But other than that, this show, that's sort of our MO. That's our...
depression. Factor number 3 is family status. And by status, they mean household size. So the bigger your household, the steeper the showing is that you have to make. And that's considered primarily in relation to factor 4, which is assets, resources, and financial status. It's already the case that the sponsor has to demonstrate household income at or above 125% of the poverty guideline, but that now needs to be shown by the applicant and her household. So this is going to be first and foremost a real problem for anybody who has a non-residential joint sponsor. If you don't have somebody living in the household, so the visa petitioner primarily, who's got income at 125% of the poverty guideline, and instead you're relying on, your best friend Joe who lives in Montana, that's now going to be a problem because that's not going to be household income for purpose of this rule.
Mm-hmm. Are they considering it all the income of the beneficiary or the immigrant? So oftentimes, my clients have been working here a long time. They're working illegally. They don't have work authorization. And I know under the 864, under the old rules, their income didn't count.
Yeah, and there's actually a bit of a departure from that, which I was surprised to see. And this showed up in the final rule, even though it wasn't in the October 2018 draft. But under the final rule, income from unauthorized employment actually can be counted.
Oh, so that's kind of good, actually, right?
Yeah, it's good and frankly kind of surprising to me. So if the applicant herself is unauthorized and working, that will be considered, so long as it's not from a, quote, illegal source. And the examples of that are things like prostitution, gambling, and drug dealing.
Mm-hmm.
I think they said that in part just so that they could put drug dealing a whole lot of times in the rule.
Right.
Since that's what all of our clients do.
Yeah. Well, one hand giveth and the other taketh away. So I guess all my drug dealing clients are going to have to sit this one out. But the idea from before that your wife doesn't quite make enough, or the petitioner, so you could go find a friend or maybe your boss to sign off as a co-sponsor, it's not being totally done away with, or it's just being weighed less than before?
Well, it is still absolutely required to get past the affidavit of support.
Okay.
Because that part of the test is effectively categorical. You've either got a good enough affidavit or you don't. And if you don't have a good enough affidavit, then you're screwed, and we don't even get to the rest of the rule.
Okay.
But what is the case is that if you're relying on a joint sponsor who doesn't live with you, that's going to be a problem.
I see.
Because it says per se that your household income isn't good enough.
Oh, okay. So it's a pretty bright liney then, right? Why require it on the one hand if later on you're going to say that it's disqualifying?
Yeah, I mean, it's required because the statutory provisions of the I-864 say that you got to meet that requirement.
All right, cool.
To meet public charge.
All right, cool. Great. Awesome.
Now, also on this factor of financial resources, there will be a litany of things that are required for the applicant to file. So for the I-864, you have to file 1 year of tax returns. That can be either the W-2 and 1040 or a tax transcript. But for the new I-944, you have to file 3 years of tax transcripts, 12 months of bank statements from all of your deposit accounts. And then if you're using assets, any shortfall of income, just like you can on the affidavit of support, and you want to use a house, that now has to be a licensed appraiser. So for the affidavit of support, sometimes you can scoot by just using like Zillow or some online free appraisal of a home value, but you now have to get a licensed appraiser to come out, take a look at your property.
Okay.
Oh yeah, and the other really fun thing for the asset part of this is that liabilities now count against you. So it's not only how much money you make, it's what your financial liabilities are. So you've got to file a credit score and then explain away if you have things like consumer debt, etc.
I mean, most of our clients, well, at least my clients, don't have social security numbers, so they wouldn't need to file a credit score or a credit report. Is that right?
Well, they do. They have to either file it or explain to CIS why they don't have one.
Great. Is there a sense of how these things weigh against each other? I mean, what about a petitioner with decent income but a lot of student debt? Do we have any sense of how these things are offset?
No, not really.
Okay, cool.
And that goes, I think, to a point you were alluding to earlier, which is, what we have now is this kind of fog of a 7-factor test with embedded sub-factors and mushy standards on every level. So what that basically does is if you've got a family who's in any sort of borderline situation, an adjudicator could find negative stuff in there.
Right.
And then, weigh the apples against the bananas and come up on the wrong side of admissibility.
Even just thinking about myself, we've got a home loan and student loans and some credit cards that we don't need to get into.
Well, God, just take the average law school graduate, right, with $200,000 of debt.
Right. So, I think what makes this especially foggy is that, when we combine this and the sort of unknown of how it will be weighed or adjudicated, along with some other recent changes at USCIS, namely that they can reject a petition outright if it's incomplete or if they're unsatisfied, and also that they'll be referring more cases to the immigration court, it makes the whole process a lot more risky, right?
Yeah, and worth noting is that Department of Justice, which of course contains immigration court within its warm embrace, is actually revising its own public charge rules. So what that almost certainly means is that we're going to have, interlocking rules that make it, automatic or really likely that if you get a adjustment denial based on public charge, you're getting an NTA right after that. So that really would up the stakes.
Right. So Were there other factors? Did we get through all 7? I mean, I'm sufficiently depressed, but if
There's more good stuff. Hang in there. So factor 5 is education and skills. So sort of like an old G325A form or the I-130 supplement, the applicant now is going to have to show her work history. And one positive thing here is that unlike the draft rules, there actually is an exemption for primary caregivers. So if you're a stay-at-home parent of a minor child or individual with a disability, you're not exempt from public charge and admissibility, but they will consider the fact that that's your sometimes thankless and always unpaid job. So that's a good thing. You have to prove that you're a stay-at-home caregiver, and I can't quite imagine how a stay-at-home dad proves that he's a stay-at-home dad. Maybe with Facebook pictures.
They don't like Facebook for some reason, but yeah. Interesting. Okay.
But then on top of that...
Oh, great. There's more.
So you have to document what sort of skills you have. You need to give them your high school transcript, give them copies of any licensures you have. And a big one is that you have to demonstrate English language ability. And this is a part of the rule that I really don't know how this is going to work out in practice, because they certainly haven't codified any sort of formal test at the interview stage like we're familiar with for the N400. And instead, you have to prove up your ability with all of the certificates that you have for English language courses that you've taken. Well, I mean, lots of our clients who have perfectly fine English don't have any certificates to prove it. Maybe they've just been working in an English language environment for a long time. So I don't know how that's going to get actually adjudicated, but it's right there in the rule, and that's a potentially really big deal for a lot of our clients, right?
Right. I guess it's a repetition of a question I already asked, but is this a de facto factor or one that's just weighed in a certain way that we don't understand? Or
So, I mean, with all of these factors, DHS is really careful to say that no one factor is make or break. And that includes English language ability. So they're real careful to say, well, this isn't a requirement. It's just something we're going to look at.
Right.
So there's no defined standard of what it means to be English language proficient. So there aren't any goalposts. It's just something that's going to be considered.
Okay. Well, it seems like if they wanted to, they could deny virtually any case.
Yeah, I mean, that of course probably overstates the disaster a little bit, but probably not by much. And we haven't even gone through all of the tests here, but probably the main exception to that is that there are these heavily weighted factors, potentially the most important of which is income at or above 250% of the poverty guideline.
Wow.
And so if you're in that income bracket, you should basically be fine, period. But that, of course, excludes a lot of people.
Yeah, that's...
But even, I suppose, you could even be in that 250% bracket, and if you had a lot of consumer debt, or if you didn't speak English, you're definitely not 100% safe.
Right. Okay, this is really depressing. Were there any other tests that you wanted to mention?
Yeah. So the other factors are prospective period of admission. So this now applies to non-immigrants seeking to change or extend status. That's bad news. The good news is that those folks are going to be held to a much lower standard in effect. So if you're changing or extending status, the only thing CIS is really going to look at is whether you've been receiving public benefits while you were here on a non-immigrant status. And since most non-immigrants aren't eligible for those programs, you're going to be more or less safe. So that's good news.
Right.
Non-immigrants will largely be fine. And then the last factor is the affidavit of support. So even with respect to the affidavit of support, it's not going to be sufficient just to have it in your file. The CIS officer is now going to look at the likelihood that a sponsor will actually provide support.
Oh, I see.
Which I think means, and we've seen this at Ciudad Juarez for over a year now, that if you've got, your spouse who signed the affidavit of support and is living with you, well, you're going to be fine with respect to that factor. But if you've got Uncle Bob, or even worse, distant friend Bob, who signed a joint sponsor affidavit, that is now going to be viewed with extreme suspicion by USCIS.
Right.
So again, I think the bottom line there is joint sponsor cases are problematic. That's the takeaway.
Right. So one of the big questions we're getting is what counts? And again, it's forward looking, right? So if you got benefits last year, that's maybe a negative factor, but it's not per se disqualifying.
Right. It doesn't sink you automatically.
What are the things that I'm allowed to get in the future as a permanent resident being admitted? And what are the things I'm not allowed to get?
In terms of public benefit programs?
Right.
So the list, let's just go through what's on the excluded list. I've probably spent 40 hours going through this rule this week, and I still can't keep this all in my head. So the naughty list for public benefits is eight programs. Those are SSI, TANF, and other general cash assistance programs.
Mm-hmm.
SNAP, food stamps, and then Section 8 and Section 9 housing programs, and then finally Medicaid. Things that aren't on that list, which we thought might be included, are WIC, so that's the supplemental nutrition program for women and children. That's not on the list. Medicare Part D isn't on the list. And then there was also previously this kind of catch-all provision for long-term care, and that's not on the list because DHS realized that Medicaid is basically the long-term care program.
Right. What about people who are on the exchange? They have like Washington State Obamacare.
Yes. Okay, so receiving healthcare under the ACA is something that DHS had considered treating as a public benefit. And it no longer is, but there's a major caveat, which is this, that applicants now have to demonstrate that they have health insurance when they file the I-944. And it's not per se required that you have it, but you have to file proof of whether or not you do have health insurance. And if you are enrolled in a program from the exchange...
Hold on. I thought forcing people to have insurance
was a bad thing, right?
This was the epitome of tyranny. I mean, this was not a small thing over the last 12 years, right? This was perhaps the most important plank of the Tea Party, the entire...
It still is.
The entire conservative movement since 2009. And okay.
Wait for it, because they have some anger left for the ACA.
Okay.
So
okay.
If you have health insurance through the exchange and you're enrolled in a policy that gives you tax credits, so that's primarily for folks under 250% of the poverty guideline, that's going to be viewed negatively under the new rules. So there's where you get your...
Okay, but that's a negative factor for determining the need for future public benefits, but it's not itself a public benefit.
Correct, yeah.
Okay, so in the future, you could continue to receive it, but they're going to say that, receiving that benefit might make us think that you're likely to receive the naughty list.
They would rather have you on a non-subsidized insurance policy. Yep.
Okay, crystal clear. For a lot of folks, maybe their U.S. citizen spouse has received some benefits, or their children, maybe their wife is technically the one receiving housing benefits, or some of those things. So how does that play in?
So there's actually some good news there. The proposed rules would have effectively penalized a foreign national if a household member had received benefits, which is crazy, right? That if you had a U.S. citizen child who was lawfully enrolled, in SNAP, that you would get penalized for that. That's, that really had people pissed off. And that actually disappeared from the final rule. So if you have other household members receiving benefits, that is not a strike against the applicant. So, for example, if the household is receiving Section 8 vouchers, but the enrollment paperwork doesn't list the applicant, then they're actually okay. Another thing, just to kind of triangulate how horrible this is, there are exceptions for Medicaid. So emergency Medicaid is okay, as is Medicaid received by folks under age 21 and pregnant mothers. And that actually gobbles up a pretty good tranche of the immigrants who are actually eligible for Medicaid. Because remember, under PWORA, the 1996 welfare legislation, most new immigrants can't receive public benefits, period. So to receive the benefits in the first place, you have to fall into a special exception. And those exceptions in this rule more or less account for most folks who are going to be enrolled in Medicaid.
What are your predictions? I mean, assuming, let's say the thing gets rolled out and it's not stopped by any type of judge, How do you foresee this affecting the system as a whole?
One thing to really underscore is that this is prospective only and doesn't go into effect until October 15. So the first thing that it should do is light a fire under everybody's butt to get filed before October.
True.
If you've got clients out there in your orbit who have been dragging their feet, getting their paperwork together, and certainly for community members who are kind of thinking but not really committed to adjusting, like now would be the time to get that thing postmarked, because you simply won't be subject to the rule if you get filed now. So I think this will be maybe a smaller version of the 245I rush to get everything in before the hammer comes down. I mean, we've already seen since the FAM revisions went into effect that inadmissibility findings on public charge grounds have gone up. Forgetting my stats here, I believe it was 6 times.
Right.
And these DHS revisions are substantially more harsh than the public charge rules in the FAM. So I think we're really going to start seeing people either not applying or getting found inadmissible on public charge grounds.
For people who might have missed that, folks applying from abroad. So my wife is in Ukraine and I want to bring her over. She's applying at the consulate abroad. These rules, or some of these changes have already been implemented, and we've seen the denials go way up. And these particular changes are for people already in the United States, and it goes far beyond the changes at the consulate. Is there a chance that the USCIS adjudicators go, whatever, we're taking this new form and a bunch of new evidence, but we're not going to dramatically change the way we adjudicate these cases? Or do you see it going the other way and them really leaning into it?
I bet what we'll see is big divides between different CIS offices. I'm out here in Seattle. We actually have, I think, a pretty good office here.
Mm-hmm.
But the offices that are legitimately viewed as bad are going to have a lot more ammunition to get worse.
Right. Yeah.
So maybe we get in a situation where it's so bad that we start to see forum shopping.
Yeah, that's true. Let's see. We've got a couple questions. Matthew asked, are you bringing donuts? And I think the answer is no. Do you see this change more as a sort of escalation of existing trends or a significant break with the past?
Oh, it's a huge break from the past. Unless I'm missing something that happened in the earliest days of the Republic that didn't make it into the history books. This is by far the most draconian standard we've had for assessing public charge inadmissibility. We have never seen this much scrutiny applied to the self-sufficiency issue.
So Justin asks, how transparent are the metrics for determining eligibility? Do you know how many people are rejected because they're too poor? Are there projected numbers yet of how many more will be excluded and why?
I'm trying to think if those were in the stats. I don't believe CIS made a forecast of that. It would just be pulling a number out of thin air because, there's just so much discretion in the application of these factors. It's not like they defined a particular income level that they could pull data on.
Right. So, on the one hand, the metrics are transparent because you just told us about them. You spent all week reading about them. On the other hand, it seems to be a total mystery what will happen moving forward.
They're ultimately extraordinarily subjective and qualitative. With the affidavit of support, you either make 125% of the poverty guideline or you don't. You can get into some arguments about what income counts, and you can argue about whether assets can be converted to cash, etc. But ultimately, your income is what your income is. But here,
exactly,
your income is one part of an otherwise very subjective puzzle.
Right. Nancy wants to know if there's anything states can do to mitigate this.
Well, they can sue, which is what they've been doing. Washington State Attorney General Ferguson filed a suit with 13 other states. I guess states could provide some protection to immigrants by helping people be sophisticated about enrollment decisions they're making.
Right.
One of the things that I think folks are rightfully concerned about is that families are going to forego benefits that don't actually carry a public charge consequence. So, for example, emergency Medicaid. Maybe you have somebody forego really serious medical treatment because they're worried about getting dinged with inadmissibility down the line, even though emergency Medicaid is carved out. So helping people at the ground level understand correctly the consequences of benefit programs is going to be really important.
Let's say you're an oil tycoon and you're petitioning for your wife and you've received billions of dollars in subsidies. How does that calculate in?
Yeah, or a real estate mogul with a lot of daddy's money, maybe?
Yeah, who's never paid taxes. So that's a really good point, what you said about people foregoing things that they qualify for. We've had people since last October, including asylees or people with U visas, things like that, saying, I took my daughter off of the exchange. We no longer have insurance because we heard that we're going to be rounded up and immediately deported if we get something like that. And it is important for people to know sort of who's affected by this and who's not, what things you can get and what things you can't. I do have a quick question. Do you have any sense of whether or not, I mean, this seems to be for people applying for adjustment, but what about people returning LPRs who are seeking admission after a vacation in Mexico or
everyone applying for admission?
Right.
So good news is that those folks don't have to file the I-944 form. Thank God.
Right.
So you don't have to show up at the port of entry with 700 pages of financial documents. But CBP, Customs and Border Protection, is part of the Department of Homeland Security. So the new standard, the substantive standard about what public charge means, does apply to CBP. That certainly has not been the focus of my analysis of the new rule, but they are subject to making public charge determinations. So I guess, if you present with any sort of issue that gives, the primary inspector suspicion about whether you're a person of means, they can divert you to secondary and grill you on it, I suppose.
Yeah, and it's hard to know these days, like, whether or not to lead people down some scary thing that might not ever happen, or to point out, like,
right,
this is a legitimate tool that's been placed in the tool belt of some people who like using tools.
Right.
and maybe it's something to keep an eye on. I mean, there, again, not to be using scare tactics, but there's a real potential that somebody who's been a permanent resident their entire life, or virtually their entire life, could go on vacation and come back and be detained and placed in removal proceedings because we think they're too poor, essentially, which is crazy.
Well, and I think if you want to go down a scary path, what could be happening is if CBP and DHS systems start talking well to the enrollment systems of public benefit programs, that's where you could have an issue. So if a CBP inspector gets a heads up on her computer, if you've been enrolled in Medicaid, that's a scary world.
Right.
That doesn't seem out of reach.
All right. Well, do you know of any other areas of law that are hiring? I don't have any other skills, but I might just be done with this.
Pizza, man. Pizza.
All right. So you and I, we're going to go into the pizza business.
Just make sure you're making at or above 250% of the poverty guideline.
All right. Well, Greg, this was really enlightening. I know people have a lot of questions. It does seem like, again, if we take a broader view, like I mentioned at the beginning, there doesn't seem to be a real problem that's being fixed here. Instead, it seems pretty clear that the acting head of USCIS, who's kind of an enforcement guy, is looking for another tool to deny applications. And boy, this seems like a really pretty powerful one.
Yep, it's part of the trend that began right out of the gate with the Muslim ban to decrease immigration.
Right. And again, this is a piece of evidence 4,785 in my case to prove that when people say do it the right way, they mean don't do it at all.
Right.
The do it the right way people should be up in arms, right? This is absurd. This is crazy. This is going to serve as a barrier for people who do want to do it the right way. Because that's what this is. These are people literally doing it the right way. Greg McLawsen, thanks again for coming on, and good luck with your seminar later.
No problem. Happy to do it.
All right. We'll talk to you later.
Bye, Steve.
Rischi, meu nome é do seu caderno, pois não suporto o inferno do nosso amor fracassar. nuevos caminos, en busca de otros cariños, matémonos o pasar. Mai se algún dia talvez a saudade apertar, não se perturbe, afogue a saudade nos copos de bar. Creio, toda quimera se esfuma, como a brancura da espuma que se desmancha na areia. Mas se algum dia talvez a saudade apertar, não se perturbe, afogue a saudade nos copos de bar. Creio, toda quimera se esfuma, como a brancura da espuma que se desmancha na areia, que se